Prosecutor versus felon. That's now become the framing of the election between Vice President Kamala Harris, a former prosecutor, a former attorney general, a former senator, now the vice president and top of the Democratic ticket. Donald Trump, a convicted felon, someone who's been found liable for sexual assault, someone who's been found liable for systemic fraud. Harry, we need to talk about, though, the case where Donald Trump was convicted on the 34 separate felony counts. We know the United States Supreme Court, in their absolute immunity order, not only cloaked the presidency, or in this case, Donald Trump's conduct, since Trump had appealed to the Supreme Court, an absolute immunity for core constitutional functions, also for official acts. But the Supreme Court did something Donald Trump didn't even ask for. They also provided some evidentiary exclusion rule for evidence that relates to official acts, where there could be a presumption that the acts are official in the first instance, such that evidence relating to a president, in this case Trump's time in the White House, could not be used in any other criminal cases at all. And we know from the Manhattan District Attorney criminal case, there was certain evidence that was introduced, even though the criminal conduct clearly relates to conduct before Donald Trump was ever in office. There was evidence about Donald Trump's mens rea, his mental state, of things he said during acts, conduct while in the office, things he said to Hope Six, things he said to Westerhoos, his assistant, having people over at the White House, posting from his official White House account at the time. And so Donald Trump filed a motion with Justice Merchan saying, look, you have to now throw out my conviction in the Manhattan District Attorney criminal case because of the evidentiary exclusion rule, not the underlying act, but all of this evidence came in. It's prejudicial. You have to throw out the case. Now, you and I were wondering, okay, what's this district attorney brief going to look like? And I thought it was powerful. It talks about Donald Trump's waiver of certain arguments. And then it also talks about, even if there wasn't a waiver, Judge, you've now have a full evidentiary record in front of you, so you know that any presumption that could exist that these were official acts are rebutted. This conduct is clearly unofficial, and as a result, these charges should stick. You already do the balancing analysis or whatever the Supreme Court wants you to do because you saw it. And so let's sentence him, put him in jail. We have sentencing coming up in September. This Supreme Court decision doesn't matter one iota. What do you think, Harry, about this? They came out swinging.
Yeah, they did. Let me first, I just going to start on where you started and the rhetorical prosecutor versus felon. This ready-made line, I prosecuted sexual predators. He is one. Is wow, just what a haymaker. Okay, you're right, Ben. It's comprehensive. It's something else. It is meticulous because of the incredible sort of overreach of the Supreme Court, and especially this evidentiary rule you're talking about. It forces Bragg to go march step by step by step by step with each bit of evidence. And you're right, sometimes he says waiver, because there are a few ones where Trump made an objection based on immunity, and the law in New York is if you don't, you waive it, even if it's based on a later Supreme Court case that people didn't know was coming. So you have waiver, then the thrust of the case is this doesn't fit under the Supreme Court test, and then the final layer of harmless error. Even if you actually admitted it in error, there's still really overwhelming evidence and no reasonable juror would find otherwise. That, by the way, is a really solid kind of means for a trial judge to rule, because the trial judge was there. I was there, as you know, at the trial, and it's just true. Hope Hicks, who's I'll explain in a moment, but that's going to be the real focus. She got up and said things, and it was, as the prosecution said, devastating. She cried on the stand, but she was there basically to say what a total frenzy and panic the whole campaign was in when Stormy Daniels came forward in the wake of Access Hollywood. And man, we had evidence of that just, in every direction, David Pecker, Michael Cohen, and the like. Okay, so to really go through this, they do it very well. You have to do every piece of evidence. So what are their tweets? But he never even tried to say there was immunity there. There's a OGE form, a financial ethics form, but I think the Supreme Court says in the immunity case, an official record you can get in, and then the focus will be on Hope Hicks. And here's the deal. After all this happens, the pretrial conduct in 2018, he's the president, and the Wall Street Journal does the story about this. And she comes in and says, oh, they've just published this and the like. And he says, oh, good thing it was now and not before the election, which of course is very strong evidence of what they were doing. But you have the Supreme Court of the United States being so expansive. So let's just think about that conversation. They're in the Oval Office. On the one hand, here's your communications director. Here's Trump talking about this story. And if you have this really broad categorical approach that the Supreme Court seems to endorse, is that sort of automatically, categorically, generically official? Or what the AG says is Bragg parses it more finely. He says, look, they're talking here, but they're talking about unofficial conduct, and it's unofficial conduct, even the conversation, because Hicks isn't there for any, as Bragg puts it, forward-facing conduct of spinning it to the public or doing the official things that a communications director does. It's just this Hope to Donald kind of private conversation, and that seems right to me. But if it's wrong, the harmless error argument is I think quite strong here. An important point: the waiver argument not so strong. It's a little. You still have an argument, and Bragg makes it. But Trump definitely twice in trial said, "Hope Hicks, this is immunity. There's a problem." So that's going to be first to test where the court is. How broad is it? Is it just enough that they're in the White House and she's his communications director? It shouldn't be, because you want to look at facts and context, as the court says, and it really isn't official. But let me give you the sort of bottom line. I think Merchan will deny this, and he will base it a lot on harmless error, and that's a really hard thing to overturn, and it should be. The trial court saw it. I think the appellate division, the appeals and the next level of the New York courts will do the same thing, and I think the Court of Appeals, which is like the Supreme Court, the highest level in New York, will probably take the case, and B, I think also will probably deny it. And then we have, the big top circus and on 1 First Street Northeast. Will the Supreme Court then reach down and somehow upset the apple cart again? But look, if we are here, as you say, Ben, Kamala Harris has won, and the whole time urgency goes away. That would be a reversal. But this case, it wouldn't make it go away. The very, very worst thing happens is a retrial, which I think Bragg would do. And I think even more likely, why does the Supreme Court of the United States want to take a case based on harmless error analysis? That's like the definition of a, fact kind of bound question that the Supreme Court doesn't deal with. But I just want to point out the dynamic in all of these have changed. On the one hand, they've changed in a precarious way, because if Trump wins, each of them, but maybe not New York, are in all kinds of hurt. But on the other hand, if he loses, so it's 2025, 2026. It doesn't, he still has a date that he can't escape. And the jeopardy, the sword of Damocles, as the lawyers say, hanging over his head. So in that sense, it's still a big problem. But keep your eyes on, all you Midas listeners, that Hope Hicks testimony and what Merchan says in particular about harmless error. Because A, I think it's right, and B, it's a bottom line that it shouldn't matter what the Supreme Court ultimately decides and whether this was immune stuff. If it's harmless error, it's harmless error. And I was there, Merchan was there, so much evidence, it's harmless error.
Let me give you my prediction. I
All
think
right.
Justice Merchan denies Donald Trump's attempt to try to dismiss this.
Yep.
We move on to sentencing a week later or so in September.
That's the whole big thing, right? September, that he will not, I'm sorry to interrupt you, but that's the one thing that does matter for the election. Does the September 18th sentencing go forward? And I agree with you, it will, but let me get back to you. I don't know if it's a week, but September 18th.
September 18th, 10 a.m., that's when it'll take place. So you do the sentencing then, and, I think he will stay the sentence pending the appeals. I think he'll give a stiff sentence. I think it'll be a real sentence. Look, sentencing you to, 18 months, 2 years, based on the conduct that was but I'm going to stay it. You can go and appeal it. And you think less.
I mean, that for this crime, that would be more than stiff. That would be brick wall stiff. But I agree with you, a few months, because in the run of these crimes, you'll often get a non-custodial sentence. So a custodial one will be serious, just for political reasons, to hear the court pronounce, you must go to jail, Donald Trump, when this is all over. Yeah, that's serious in and of itself. But I don't see us getting that high. But the big difference is jail or no jail.
Well, we will keep everybody posted each step of the way here. But, as a lawyer, I really appreciated the way they engaged with a very challenging Supreme Court order and how they framed it exactly as you described accurately to deal with all of the landmines. And that's no easy task. I have to imagine they consulted some of the best appellate lawyers who parsed through that Supreme Court decision and really crafted every word in this brief was intentionally chosen. It was not just someone typing, quite literally. Every word had been analyzed and reanalyzed given the stakes. And that's why we like analyzing it for all of you. The best place to get that analysis, other than the MeidasTouch Network, or I'll say equal to the MeidasTouch Network, is the Talking Feds YouTube channel, led by Harry Littman. That channel's on fire. It's doing incredible. Hit subscribe there and help that channel get to 500,000 subscribers. Just search Talking Feds YouTube. Thanks, everybody.
Thank you so much, Ben. And a quick point to add, they are meticulous and they write it for Merchan, but they know there's another audience, the appellate courts, even up to the Supreme Court. So that's part of what makes it a really professional job. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.